If the court does follow the recommendation and do a time served, you're still not getting out today, Mr. Connors. Until you pay $500 down, you will not be released.
How the heck am I supposed to get $500 while I'm in here?
I don't know, you figured I am going to order 3 months imposed but stayed jail for that. So if you don't do what you need to do, then you...
What you just watched? That's the sound of a man realizing his freedom has a price tag he can't afford. Richard Connors thought a plea deal meant going home today, but he was dead wrong. On the surface, this is just another case of driving while revoked and disorderly conduct. But beneath the paperwork lies a $13,000 debt Richard claims he didn't even know existed. He insists his taxes handled the bill, yet the transcript reveals he hasn't even filed them in years. Now, he's trapped in a high-stakes legal catch-22. To walk free, he needs $500, cash he simply can't earn while he's locked behind bars. How does a man pay for his liberty from inside a cell? If you want to see how the legal system catches a lie in real time, hit subscribe for more deep dives into these courtroom battles. Let's head back to the beginning of this sentencing.
We will go on the record in the matters 25 CM 180, 26 CT 16, State of Wisconsin versus Richard Connors. This date appears through District Attorney Kevin Schmidt in person. We have Mr. Connors appearing in person in custody with counsel Joel Flisky. We're set today in this matter for a plea and sentencing. Mr. Flisky, the parties have reached an agreement. What is the agreement that's been reached?
Thank you, Your Honor. The parties have reached an agreement to resolve these matters for Mr. Connors to plead to the sole count in both 25 CM 180 along with 26 CT 16. We will be making a joint recommendation on 25 CM 180 for Mr. Connors to complete an AODA assessment along with court costs, and for on 26 CT 16 to be sentenced to time served. I have credit here for 17 days from the time of his arrest on March 31st of 2026 until today's date. If I did not already say to the court, there will be court costs on each count. I have a completed plea questionnaire, which I've reviewed with Mr. Connors. May I approach?
You may. For full disclosure, if the court does follow the recommendation and do a time served for the cases, you're still not getting out today, Mr. Connors, because I need to set a hearing on your fines and fees. That $13,000 we were talking about. So do you understand?
We
that?
already did that hearing, and you
No, I
said
didn't.
30 days, I thought it was.
Don't believe I
thought we did it, what was last Tuesday or whatever, and you said anytime I miss a payment, $500 payment, you said you'll throw my butt right in here for 30 days.
Did you make your payment?
No, I haven't been able to, not from in
Well,
here.
yeah, you can't get out until you make that payment. You're not getting out until you make a payment.
Well, it'd be 30 days to sit then, wouldn't it?
No. It was $500 down, if I'm recalling correctly. I don't know, seeing you so much is not, I have to bring it up. You didn't bring your stuff. Go way back to whatever cases it was, way back in the day. Did you get an order on that? Because if you didn't get an order on that, then I don't.
No, I didn't get nothing.
Then it doesn't exist until there's an order. I will ask Amy.
I think we just did it on the status conference or whatever it was last Monday or Tuesday.
And my recollection is $500 down. Yep. Court will accept $500 down payment for failure to pay, $500 per month, 30 days in jail if you fail to continue each month. So yes, we did already have that. So until you pay $500 down, you will not be released.
So I'm in here until I get $500?
Correct.
How the heck am I supposed to get $500 while I'm in here?
I don't know, you figure it out. And then if you can't, then you write the court and we'll have to have another hearing. All right. Yes, you're correct. We did have that hearing, so we don't have to set it. The court did make an order, and then if you can't come up with $500, then that's where you have to write the court and plead. Otherwise, if you can't make the $500 payment, then honestly, then the stay gets lifted and you have to sit that 30 days.
So 30 days then?
We'll see. All right, so I have the plea questionnaire waiver of rights form. Do you recognize the document?
Yes.
Okay. Did your attorney go over that with you?
Yes,
Did he go over it thoroughly with you?
yes,
And you understand it completely?
yes,
Okay. Is that your signature on the second page?
yep,
So you're pleading guilty to both of those counts. You understand everything completely, thoroughly? And if you hadn't, is that a yes?
yes,
And your attorney, if you had any questions, he fully explained it to you, tell you understood? You're 43, 12 years of schooling. You can read, write, you understand the English language, no drugs, alcohol, medications, mental illnesses or disorders. Did your attorney thoroughly go over your constitutional rights with you?
yes,
And you understand them completely?
yes,
And do you need me to go over those rights with you in any more detail?
no,
You understand that by pleading guilty, you're waiving and giving up those rights?
yep,
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
yes,
Do you understand here that the state's going to have to prove on or around, wait, let me get all the other cases that you have gone. State would have to prove on or around April 31st, 2026 in Burnett County, Wisconsin, while being a person whose operating privileges have been revoked pursuant to Wisconsin law, you operated a motor vehicle on a highway or roadway of the state. And that revocation was a result of an OWI or similar related offense. Do you understand what the state would have to prove?
yes,
Do you understand the maximum possible penalty is a fine of up to $2,500 or imprisonment of no more than 1 year in the county jail or both?
yes,
You also understand that with regards to the disorderly conduct, the state would have to prove on or around August 19, 2025, while in a private place in Burnett County, you engaged in unreasonably loud, boisterous, or otherwise disorderly conduct, which tended to provoke a disturbance. The maximum possible penalty could be a fine of up to $1,000 or 90 days of incarceration or both. Do you understand that charge and the maximum penalty?
yes,
Do you understand that there is an agreement that's been reached between the parties and it was recited on the record, but I am not bound to follow that agreement? Do you understand that?
yes,
Said differently, I could sentence you to the maximum possible penalty today if I thought it was warranted.
yes,
Do you still wish to continue and enter a guilty plea?
yes, Your Honor.
Did you go over the criminal complaint with your attorney?
Yes,
In particular, did you go over the probable cause section of that criminal complaint?
yes,
For the most part, it's actually for both of those complaints. For the most part, are those facts accurate in both of those criminal complaints?
yes, Your Honor.
Mr. Feliski, may the court use the probable cause section of the criminal complaints to find a factual basis?
So stipulated.
Has anyone made any threats or any promises to you for you to plead guilty to these charges?
No,
You're doing so freely and intelligently, telling the court you fully understand what you're doing
yes,
and voluntarily.
yes,
Has your attorney represented you competently?
yes,
Has he answered all of your questions? Right? Has he looked at this matter thoroughly?
Yep.
Has he discussed this with you, of whether or not you have any defenses or a lack of defenses?
yeah, you discussed it with me.
And you're satisfied with his services?
Yep,
Any questions for the court or for your attorney before I proceed?
no,
As to count 1 in 26 CT 16, operating while revoked, how do you wish to plead?
guilty.
As in count 1 in 25 CM 180, disorderly conduct, how do you wish to plead?
Guilty.
Court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your pleas of guilt. Based on that, I will find you guilty of both of those charges. Judgment of conviction will be entered today. Argument, Mr. Schmidt.
His disposition's appropriate. He's been in custody for a while. The cases are OAR, which he has a significant history of, and the disorderly conduct is essentially nuisance behavior that wasted a lot of law enforcement time because it appears he came under the influence of something, went out in the pond, and law enforcement had to deal with him when he was kind of just shouting like gibberish noises and flailing about. It took actually quite a few officers' time, and that's really the main cost of it. Thank you.
All right, Mr. Felisky.
Thank you, Your Honor. I concur with the remarks of the state. Again, I will note the credit on the record that Mr. Connors was brought into custody on the traffic matter here, March 31st of this year, and has been in continuous custody since. So by my math, you would have 17 days. As the state remarked, Your Honor, I think that this is an appropriate agreement. Mr. Connors has been in custody, so he's received some upfront punishment for both of these offenses. He will have the burden of the additional fines and fees to pay off of, which will hopefully prevent this behavior from reoccurring, I should say, in the future. Overall, I think that this is an appropriate agreement. I would ask the court to follow it. Thank you.
Okay, Mr. Connors, anything that you want to say or add right now?
Well, I was just hoping I would be able to get out of here within 30 days so I could start. I do work.
Then why don't you pay your bills?
I did not know I had 16 or 13. Was it 13?
$1,000, yeah.
I did not know I was coming back here. I thought it was out taking care of taxes, and I was trying to contact them and figure that out. I didn't know if it was something that I was trying to get a hold through my tribe and see if I could get the help through them and their attorney. I'd actually called and left messages up there, but I did not know that the 13,000 was going to come back to you guys. And then all of a sudden I didn't do nothing about it. I just got a piece of paper in the mail saying there's a warrant out for me and I owed 13,000 when I thought it was all going through the state, and I was trying to take care of it through the tax raise. It all backfired, and here I am.
Okay. Well, here's the deal though. You've had other fines and fees outstanding of that 13,000 though, that you haven't made payments on because you've been here, I don't know how many times in the last year or two that they haven't yet went to state debt, but we haven't gotten payments. So if you're working, then you should have money coming in, and I get you're self-employed, but you need to then come in and pay the money yourself, like come in and pay the money to the clerk. But you didn't do that.
There actually was no fines or nothing. There was nothing.
Well, there is.
3 months ago, there was nothing. There was no payments because everything was clear. They had put everything over to taxes. Everything went over there. Then all of a sudden they sent half of it back.
Did you file taxes? I
did not file yet. That's what I was trying to contact my tribe to see what to do with,
Okay.
I had some other questions.
Anyway, I'm hearing like with this case, they're not very serious. It doesn't sound like you're going to be able to get your license anytime soon. You need to stop driving. You need to stop driving because I'm going to tell you, it's not fun to have you come in for you or for me every 6 months.
It's hard being self-employed and not driving too.
I get that. And I
I
understand
had it
that.
all taken care of and I got that
Then you
woman-
need to get your license or figure that out, but it doesn't sound like you can get it anytime soon because you continue to drive. So, with regards to this matter, I don't know why fines and fees and costs, because you're never gonna pay them. So we're going to, it makes no sense to order the full amount for anything. $200 DNA surcharge for the disorderly conduct, 17 days of jail with time, that is time served. With regards to the 26 CT16, you weren't asking for probation, correct? You just want him to get an AODA?
That was the terms of the offer I received from the state.
All right, you need to get an AODA assessment, but
I have to do it anyways.
you do have to do it anyway. With the operating while revoked, that has a maximum possible penalty of 1 year. I'm putting on probation for a year. Because I'm ordering the AODA assessment. I don't have pull if unless you're on probation. Because I can't bring you in and yell at you for not doing your AODA assessment if you're not on probation. I just have to trust that you're gonna do it. So far, I don't have faith that you're gonna do it.
Is that if I go on under probation, is there a chance that I can get out here so I can make the money to make the payment then?
Yeah, after 30 days.
After
So,
30?
you're on probation, you have to get your AODA assessment and follow through. Work towards getting your driver's license or figure out what you need to do to get your driver's license. I am going to order 3 months imposed but stayed jail for that. So if you don't do what you need to do, then you It's at 3 months. And the 17 days that you sat is consecutive to the fail to pay fines and fees 30 days. And again, so you can understand, you are in custody
Consecutive or
for
concurrent?
what?
Consecutive or concurrent? So is it 30 days from now?
Consecutive. So
From
it
now?
starts from now. So if you're able to pay $500, then you pay they're separate things.
I
So
can't
if
pay
you're
all-
able to pay $500, you can get out of custody and the 30 days will just stay over there. But every day you can't pay the $500 is 1 day credit towards the 30 days. So if you sit 10 days and you're able to come up with $500, that 30 days gets dropped to 20 days. But then you have to make your $500 a month payments. Okay? Our clerk, Amy, is going to do an order so you know and you can understand, and I'll sign it to make sure that it has everything. So you're clear, the jail is clear, everybody's clear, and we know what's going to happen in the future. You know, I know, it'll have the full amount that you owe, everything, and it accrues interest. So you
Can I
know. No,
pay for
nope,
concurrent?
we're adjourned. 20 days to appeal. Should you fail to appeal within 20 days, you lose that right. DNA, you have the right to request it be expunged through the system through a written letter to the Department of Justice. If you fail to pay your fines and fees associated with these cases, not only will a civil judgment be entered against you, but a warrant will be issued and you could sit up to 6 months in jail for this alone, not the other stuff you owe, because it's for each. So 6 months in jail. So you must pay these off. These are included in your $500 a month payments, okay? Because it doesn't make sense to make you pay for each of the ones. So it's all together. These are thrown into the lump sum that you owe. And that's what it is. All right, thank you. 17 days of jail credit if he's revoked off of the other matter. No, it's consecutive. Never mind. So everything's consecutive.
Okay, so on the disorderly is the straight jail and on the OAR is the probation?
Correct,
Okay, just wanted to make sure I got that. And it's 200 DNA on both.
correct.
Okay.
Yes. All right, thank you. We're adjourned.
So the gavel fell. Richard Connors walked away with probation, but stayed behind bars until he can produce $500. But was justice actually served? Is it legally right but morally wrong to lock a man up because he's too broke to pay? Comment below, Team Richard or Team the Court? Hit like if this case got you thinking, and share it with someone who loves a legal debate.